speaker. This is Bob Neiman. Bob, over there, he is a longtime CCCBA bar member. He's been a member of the bar for nearly 40 years. Practice currently as a mediator, arbitrator, and also as a public law consultant. He has some limited experience out here with adult law matters, and we'll talk more about that in a few minutes. Bob also has the distinction of catching probably every bad ground ball, I think, second in the last 10 years as a co-softball player with me. So please join me in welcoming Bob Neiman to come up here and introduce our next speaker.
Thank you, Jay. Good afternoon, everybody. I have a great opportunity today to present Erwin Chemerinsky to you. I had the great privilege of hearing then Professor Chemerinsky speak on a number of occasions when I worked as a staff attorney with the Court of Appeals, when he made sure that we on the Court of Appeals and the staff attorneys with the Supreme Court stayed abreast of things that were going on with the U.S. Supreme Court. Then Professor Chemerinsky is currently the Dean of the UC Irvine School of Law, and I'll come back to that in a minute. Professor Dean Chemerinsky was born and raised in Chicago and attended Northwestern University. Then he went to Harvard, and after Harvard he practiced law for a period of time in the East before he took a position with DePaul University as a professor of law in Chicago. He was recruited away from DePaul to USC, where he spent 21 years as a great scholar and teacher. He was also the director of the Center for Communications, Law, and Policy while he was at USC. He then went to Duke University, where he was a professor for 4 years. And several years ago, he was recruited to become the founding dean of the UC Irvine School of Law. Quite a daunting task, requiring him to do everything from develop a curriculum to hiring faculty to making judgments about renovations of buildings to just about anything and everything you can imagine. He is extremely proud of what he's accomplished, as he should be, as all of the others who assisted him with that process are and should be. He is a renowned scholar. He has published over 200 law review articles. He has published 7 books. He is a consultant for television in Southern California and throughout the nation on matters pertaining to criminal law and constitutional law. As the founding dean of the UC Irvine School of Law, he can be extremely proud, as I said earlier, because his very first class, which took the bar in 2012, had a passing rate of 91%. And that was second only to a school that I cannot name on the eve of big game. Not that I would name it anyway. That said, it's amazing to me with all that's on his plate, although he just finished lunch. With all that's on his plate, he took the time to come and talk to us. I know you're in for a great pleasure in listening to him. One final note, it's especially nice that he came to listen to us, or to speak to us today, because his second class has just taken the bar, and the results are due out today. So he's a tad on edge, so I'm glad that we fed him well. I know that you're going to enjoy this program. I'd like you to meet and greet Dean Erwin Chemerinsky.
Thank you so much for the incredibly kind introduction and a warm welcome. It's truly my honor and pleasure to be with you this afternoon. This is an amazing time in the United States Supreme Court.
On Wednesday, June 26th, the Supreme Court dismissed the litigation concerning California's Proposition 8. 2 days later, on Friday, June 28th, same-sex couples began to marry in California. The Supreme Court's other decision with regard to marriage equality on June 26th declared unconstitutional Section 3 of the Federal Defense of Marriage Act. As a result, same-sex couples who are married in soon to be 16 states that allow them will now get benefits under 1,100 federal laws that previously only opposite-sex married couples could take advantage of. The Supreme Court's other decisions during the week of June 24th will affect who gets into college and who doesn't, who gets to vote and who doesn't, who gets elected to public office and who doesn't. My real goal is to give you an hour of painless MCLE credit. I'm very mindful of bar requirements, so I will go the hour, but I'll take a few minutes towards the end for questions. What I'd like to do is identify for you several themes about the current court, cutting across many different fields about where it is and where it's likely to go in the foreseeable future. My first theme is that when it matters most, it's the Anthony Kennedy Court. I know our tradition, in deference to the chief, we refer to this as the Roberts Court. But at least with the respect of lawyers who stand before the justices and write briefs to them, this really is the Kennedy Court. Last term, Justice Kennedy was the majority when they named the justice. He was the majority in 91% of the decisions. In fact, for each of the 8 years that John Roberts has been Chief Justice, Anthony Kennedy's been the majority when they named the justice. But it's the 5-4 decisions where you really see the importance of Kennedy on this court. They, almost always the most important cases, and by definition, the most controversial. Last term, the Supreme Court decided 73 cases after briefing and oral argument. 23 of them were resolved by a 5-4 margin. That's worth noting in itself. About a third of all of the cases were decided 5-4. Justice Kennedy by far was the justice most often the majority in the 5-4 cases. Justice Kennedy was the majority in 20 of the 23 5-4 decisions. The runner-up was Justice Scalia, but he was the majority in only 13 of the 23 5-4 rulings. Indeed, for each of the 8 years that John Roberts has been Chief Justice, Anthony Kennedy's the majority in more 5-4 decisions than anyone else on the court. I think then that you can get an overall sense of the ideology of the Roberts Court by focusing on the 5-4 decisions that are split along traditional ideological lines and seeing where Justice Kennedy lines up. Last term, there were 16 5-4 decisions. On one side, you had Roberts, Scalia, Thomas, and Alito, and on the other, Ginsburg, Breyer, Sotomayor, and Kagan. Justice Kennedy was the conservatives in 10, with the liberals in 6. I've added this up to the 8 years that John Roberts was Chief Justice. When the court is ideologically divided 5-4, Justice Kennedy was conservatives about 70% of the time, with the liberals about 30% of the time. As I said, if nothing else, this is relevant for the lawyers who practice in the Supreme Court. A week from this coming Wednesday, on December 4th, I'm going to be arguing a free speech case in the United States Supreme Court. I give away no secrets when I tell you that my brief was a shameless attempt to pander to Justice Kennedy. If I could have, I would have placed Anthony Kennedy's picture on the front of my book. My brief is not unique among those filed in this case. This case is unique among those in the docket. Everyone knows, and the justices know, that this is the Kennedy Court. My second theme is that what's missing in the court's Fourth Amendment jurisprudence is a theory of informational privacy. Each term, there are a large number of Fourth Amendment cases. Last year, there were 5 Fourth Amendment cases. So many of society's most difficult issues early in the 21st century come down to privacy. In the constitutional context, it's often litigated the Fourth Amendment, but it certainly can come in other, employment, in the court context as well. To explain what I mean about the lack of a theory of informational privacy, let me use an example case from 2012, the United States versus Jones. Antoine Jones was a suspect with regard to cocaine trafficking. Federal law enforcement went to a magistrate judge and got a warrant that authorized tapping his phones. The warrant also authorized placing a GPS device on his car. The warrant said the GPS device that he put on the vehicle within 10 days of the issuance of the warrant that he put on the car while it was parked in the District of Columbia. Inexplicably, the police waited to the 11th day after the issuance of the warrant to put the GPS device on the car. And they put it on the car while it was parked in the state of Maryland. Everyone agrees there was not a valid warrant for the GPS device was put on the car. For 28 days, the police tracked the movements of Jones' car through the GPS device. When he was prosecuted for cocaine trafficking, the GPS logged key evidence against him. He was convicted and sentenced to life in prison. The issue before the Supreme Court was whether it violated the Fourth Amendment to put a GPS device on his car without a valid warrant and to follow him around for 28 days. I have long had a predictive principle about the Supreme Court and the Fourth Amendment. If the justices can imagine it could happen to them, then it violates the Fourth Amendment. The justices can't imagine that it doesn't. You laugh because that sounds cynical. But think about the Supreme Court cases about random drug testing. Every Supreme Court case about it upheld the practice until the Supreme Court had before it a Georgia law that required that high-level government officials be subjected to random drug testing. That was declared unconstitutional. At the oral argument from Jones, Chief Justice Roberts asked the Attorney for the United States, Michael Dreeben, whether it was the government's position that the government could put a GPS device on the bumper of Roberts' car without a warrant and track his movements. Justice Kennedy immediately followed up and asked Mr. Dreeben, was it the United States' position that a police officer could slip a GPS device in Kennedy's pocket and follow him around without a warrant? I knew at that moment it was all over for the United States. 9-0, the Supreme Court ruled against it. Justice Scalia wrote the opinion for the court. He began, as he often does by saying, that the Fourth Amendment means the same thing today was adopted in 1791. I confess to you that I find it incongruous in the next sentences we have to decide whether a GPS device on the car violates the But Justice Scalia found an English law precedent in 1765, Entick versus Carrington, and said that under it, placing the GPS device on the car would be a trespass. He said a trespass is sufficient for a search, and that therefore is a violation of the Fourth Amendment. Justice Alito concurred the judgment, joined by 3 other justices. He said it makes no sense to decide what to search in 2012 by looking to 18th century English law. He said we should focus on the reasonable expectation of privacy. He said at some point in the 28 days, following Jones around invaded his reasonable expectation of privacy. I want to suggest to you that neither the approach of Justice Scalia nor that of Justice Alito is going to be useful in the kind of cases that courts at all levels are going to deal with. Imagine that the movements of Jones' car had been followed, not by a GPS device fixed to the undercarriage, but by satellites or cellular technology. I am reasonably sure that not even Justice Scalia can find an 18th century case about when the use of satellites or cellular technology violate the Fourth Amendment. But nor do I think that the reasonable expectation of privacy is useful. We don't have an expectation of privacy when we're driving on public roads. The police wanted an undercover agent to follow Jones everywhere he went on public streets for a month. That would not require a warrant. What the court needs is a theory of informational privacy. When should we be able to get information from the government until there's a warrant for probable cause? Let me illustrate this with cases from last year. One is a case called Florida versus Jardin. Police got an anonymous tip through a Crime Stoppers hotline that there was marijuana growing in a house. A police officer went with his drug-sniffing dog, Frankie, on the front porch of the house. When Frankie got there, he gave the signal that such canines give when they detect the presence of drugs. Based on this, the police went and got a warrant. They searched the house. They found a large number of marijuana plants. The issue before the Supreme Court was whether it was a search within the meaning of the Fourth Amendment for the officer to take the drug-sniffing dog on the front porch. The Supreme Court 5-4 found it was a search, and the Fourth Amendment was violated. Justice Scalia wrote the opinion to the court, joined by Justice Thomas, Justice Ginsburg, Justice Sotomayor, and Justice Kagan. Justice Scalia said, the officer went onto the front porch, the property of the owner, without consent. That's a trespass. Of course, just a year ago in the United States versus Jones, we held that a trespass is sufficient for a search. Justice Alito wrote for the 4 dissenters. He said, it's not a trespass to go on somebody's front porch. People go on the porches of others all the time. Girl Scouts, he said, go door to door to sell cookies. Jehovah's Witnesses go door to door to solicit money. UPS and FedEx go on the front porches to deliver packages. He said, there was no trespass here, plus no search. Again, I think that both the majority and the dissent missed the point. The real question is, to what extent should owners be able to keep secret what's going on inside their house until there's a warrant for probable cause? Imagine if Frankie were a super sniffing dog, and just by standing on the public sidewalk outside the house, they've been able to sniff the presence of drugs. Would that really be any different than this situation? You might remember a Supreme Court case from a decade ago, Kylo versus United States, where the Supreme Court said pointing a thermal imaging device to a house is a search within the meaning of the Fourth Amendment, because it's learning what's going on inside. That would have been a far better approach to this case. My third theme for the afternoon is that this is the most pro-business Supreme Court we've been since the mid-1930s. You might have seen an article in the New York Times by Admiral Liptak about 6 months ago that talked about this being the most pro-business Supreme Court in decades. It was actually based on an article in a forthcoming book by Richard Posner, judge on the Seventh Circuit, William Landis, a professor at the University of Chicago, and Lee Epstein, professor at USC. From many different charts and graphs, they show the conclusion that I just stated, that this is a pro-business Supreme Court. We certainly saw it last term in many cases in different areas. Let me give some examples. I think a particularly important case for those of you who do business and commercial litigation was American Express versus Italian Colors restaurant. Italian Colors is a small restaurant. it takes American Express cards. But it was upset that it paid 30% more on each transaction with American Express card than it did when other credit cards were used. It believed that American Express was leveraging its market share in a way that violated federal antitrust laws. Italian Colors brought a class action suit against American Express for violating the federal Sherman Complaint Act. However, in the agreement between Italian Colors and American Express, there was a clause that in any dispute, it had to go to arbitration. And it had to be individual arbitration. It couldn't be class arbitration. American Express invoked the arbitration clause to have a suit against it, dismissed. Italian Colors responded by saying it cost hundreds of thousands or millions of dollars to bring a successful antitrust claim. The maximum recovery in federal antitrust law, including treble damages, is $39,000. Italian Colors said, no one's going to spend hundreds of thousands or millions of dollars to recover $39,000. They argued that class action was essential. The Second Circuit agreed with Italian Colors. The Supreme Court in a 5-4 decision reversed. Justice Scalia wrote the opinion to the court, chaired by Chief Justice Roberts, Justice Kennedy, Justice Thomas, and Justice Alito. Justice Scalia pointed to a 1925 federal statute, the Federal Arbitration Act. It says, for contracts in interstate commerce, arbitration clauses shall be enforced unless they're revocable under state law. Justice Scalia said this is a statute that should be strictly enforced. He said no exception applies here, thus the suit had to be dismissed. Justice Kagan wrote for the 4 dissenters. She began her dissent by saying, let's be clear about what the majority opinion says and what it means. Because the majority opinion says and it means that a company can enter an agreement that blatantly violates federal antitrust laws and then immunize itself from any liability just by having an arbitration clause. She said the majority's response to that, and I'll quote her exact words, too darn bad. At the end of his majority opinion, Justice Scalia said that the result in this case was controlled by a decision from 2 years earlier, AT&T Mobility versus Concepcion in 2011. You might remember this case. AT&T was advertising free cell phones to those who signed up for its service. Concepcion's, a married couple, went to get their cell phones. They, like all of us, had to sign a cell phone agreement. They, my guess is like most of us, didn't read the agreement they were signing. They were surprised when they got their first monthly statement that they were each charged $30.22 in sales tax. They believed that since AT&T promised free cell phones, it should have to absorb the cost of the sales tax. They wanted to be part of a class action suit against AT&T. But in the agreement that the Concepcion signed, there was a clause, if there was any dispute, you had to go to arbitration. AT&T invoked that clause. However, as you may know, the California Supreme Court ruled in the Discovered Bank case that arbitration clauses in routine consumer contracts are not enforceable in California. The California Supreme Court said the quote, contract of adhesion. Under the Federal Arbitration Act, an arbitration clause is not enforceable if it's revocable under state law. The Ninth Circuit just ruled in favor of Concepcion's. The Supreme Court, 5-4 reversed, was more Justice Scalia wrote for the majority. Justice Scalia began by extolling the virtues of arbitration over court adjudication. Justice Scalia talked about the ill effects of class actions on businesses. He spoke of, quote, the terror effect of class actions, forcing corporations to settle even non-meritorious claims. He said that the arbitration clause had to be enforced that California law was preempted by federal law. Justice Breyer wrote for the 4 dissenters. He said that the alternative here is not hundreds of thousands or millions of separate claims against AT&T. So the alternative is really no claims against AT&T, because no one's going to sue or go to arbitration for $30.22. He said we need class actions for situations like this, where a large number of people each lose a small amount of money. These cases are so important because arbitration clauses are increasingly ubiquitous. They're found in employment contracts, in consumer contracts, even in medical contracts. Not long ago, I went to see a new eye doctor for the first time. The receptionist gave me a big stack of papers to fill out. In the middle was a form I was asked to sign that in any dispute with the doctor arising out of the treatment, I could not sue the doctor in court. I would have to go to binding arbitration. I asked the receptionist if the doctor would still see me if I didn't sign the form. She said she didn't know. Nobody ever asked her that question. I now know of many physicians who will not see patients unless they sign arbitration agreements. Around the same time, I bought a new Dell computer. As you know, in order to use the computer or an iPad for the first time, you have to click if you've read the terms and agree to them. For the iPad, it's 46 single-spaced pages of terms. I usually just click agree and use the machine. But in this instance, I decided to read the terms. Sure enough, paragraph 8 said that in any dispute with Dell arising out of the computer, I could not sue Dell in court, but I had to go to binding arbitration. I wrote Dell a letter saying I did not agree to paragraph 8, and by opening the envelope of my letter they agreed, I could sue them again. Dell did not write that. I want to give you another example of a case from last term that shows how much this is pro-business work, and again in a context that can affect each of us. The case was Mutual Pharmaceuticals versus Bartlett, decided in June of 2013. A woman in New Hampshire was given a prescription to the pain reliever Sultanac. Her prescription was filled with the generic form of the drug. She took the drug and she suffered a horrible, rare, though known side effect. 2/3 of the skin on her body burned, blistered, and decayed. She spent months in a medically induced coma. She's permanently blind and disfigured. She sued the drug company on a failure to warrant, on a design defect theory. So there was a design defect that caused her injury. The Supreme Court, in a 5-4 decision, held that makers of generic drugs cannot be sued on a design defect theory. How did the Supreme Court come to this conclusion? Well, I need to start the story a few years earlier, in 2009, with a case called Wyatt versus Levine. Diane Levine was a musician in Vermont. She was suffering a severe migraine, and she went to a hospital emergency room for treatment. She was given Demerol to counteract the pain she was suffering, and Phenergan to counteract her nausea. Phenergan is known to be a highly corrosive substance. It's supposed to be given diluted in a saline solution to an IV drip. Instead, it was given to her as a shot to her vein, the so-called IV push. Because of the corrosive effects of Phenergan, she developed gangrene in her arm, and her arm had to be amputated. She sued the drug company Wyatt on a failure to warrant theory. Wyatt argued that some state tort liability was preempted by federal law. It said its warning label was approved by the Food and Drug Administration. The Supreme Court ruled against Wyatt in favor of Diane Levine. Justice Stevens wrote for the court in a 6-3 decision. Justice Stevens said, drug companies always can engage in more speech. Drug companies take out ads in the media all the time. They can warn patients of side effects. Drug companies can send dear doctors and others physicians. Drug companies can ask the FDA to change the warning label. The court said that allowing tort liability for failure to warn would further the underlying regulatory goal of safe drugs and better informed patients. 2 years later, 2 years ago, the court decided Cleva versus Mensing. This case involves a drug that's often prescribed for those with diabetes to speed digestion. It's now known that a significant percentage of prolonged users, 29%, will suffer horrible, irreversible neurological side effects. 2 women who took the generic form of the drug in different parts of the country suffered the side effects and sued on a failure to warn theory. But the Supreme Court ruled 5-4 that makers of generic drugs cannot be sued on a failure to warn theory. Here, Justice Thomas wrote to the court, joined by Robert Scalia, Kennedy Alito. Justice Thomas said, under the Hatch-Waxman amendments to the Food and Drug Act, a generic drug can be sold if it's chemically the same as the brand name drug, and if it has the warning label that's approved for the brand name drug. He said the generic has to have the same warning label that's approved for the brand name drug. It can't change its warning label, so it can't be allowed on a failure to warn theory. He concluded his majority opinion by saying, I know it's not a consolation to these women that if they've taken the brand name version of the drug, rather than generic, they can soon recover, but drag that to Congress, not the courts. Justice Sotomayor wrote a vehement dissent. She said, this makes no sense. For the same chemical compound, if somebody takes the brand name version, they can soon recover, but not if they take the generic form. She said, we just held 2 years ago that drug companies can always engage in more speech. We just held 2 years ago that allowing tort liability furthers the underlying regulatory goals of safe drugs and better informed patients. Well, this then brings me to where I started, Mutual Pharmaceuticals versus Bartlett in June of 2013. Justice Alito wrote for the court, once more is 5-4, his opinion was joined by Robert Scalia, Kennedy, and Thomas. Justice Alito said that a generic drug can be sold that's chemically the same as the brand name drug and has the warning label that's approved for the brand name drug. He said there will only be 2 ways for the generic drug company to avoid liability. One would be to change the chemical compound, but it can't do that. The other would strengthen the warning label. We held 2 years ago in Cleva versus Mensing. It can't be sued for the failure to do that, thus no liability. Both Justices Breyer and Sotomayor wrote dissenting opinions. Justice Ginsburg and Kagan joined. They both made the same point. They said the majority sees just 2 alternatives, but there's a third. Don't sell the drug. And if you do sell the drug, then be willing to pay damages for the harms that it causes. This is so important because according to the FDA, about 80% of all prescriptions in the United States are filled with generic drugs. When there's a generic equivalent to the brand name drug, over 90% of the time the generic is prescribed. These cases mean that those who are injured by generic drugs can't sue in state court, can't sue in federal court, can't sue for failure to warn, can't sue for a design defect. The fourth theme that I point to this afternoon is that the Roberts Court wants to believe that race discrimination is largely a thing of the past. When we saw that explicitly expressed in a case called Shelby County versus Holder, decided on June 25th of this year. I think that the Voting Rights Act of 1965 is one of the most important federal laws adopted in my lifetime. Section 2 of the Voting Rights Act gives state and local governments and election systems for practices that are discriminatory effect against minority voters. It authorizes lawsuits to enforce this prohibition. But Congress knew that such litigation was expensive and time-consuming. Congress also was aware how especially southern states were continually changing their election systems to disenfranchise minority voters. Do you remember the arcade game Whack-A-Mole, where you knock it down in one place and it pops up in another? That's what Congress thought was going on in the South. The state would adopt one way of disenfranchising minority voters, it would get struck down, and then they devised a different way. So Congress added Section 5 of the Voting Rights Act. It says, for jurisdictions with a history of race discrimination in voting, they could change their election system only if they got pre-approval, technically called pre-clearance, from the Attorney General or a three-judge court in Washington, D.C. Section 4B of the Voting Rights Act is the formula that defines which jurisdictions need pre-clearance under Section 5. These provisions were, by all accounts, tremendously effective. They were scheduled to expire in 1982. Congress held extensive hearings. Congress revised the formula under Section 4B. Congress voted almost unanimously to extend these provisions for another 25 years. They were scheduled to expire then in 2007. In 2006, Congress held 13 hearings in an 11-month period. It compiled a legislative record that is 16,000 pages long. The documents continued discrimination based on race in voting, especially in the jurisdictions that need to get pre-clearance. Congress did not change the formula in Section 4B. Under it, 9 states, almost all in the South, and local governments scattered across the country have to get pre-clearance for changing their election systems. Congress then voted almost unanimously to extend this for another 25 years. Hard to imagine a Congress that would do something almost unanimously. But the vote in the Senate was 98-0. There were only 33 no votes in the House of Representatives. President George W. Bush signed the extension of the law. Shelby County, Alabama is south of Selma, Alabama. It's a jurisdiction in a state with a long history of race discrimination in voting. It brought a challenge to the constitutionality of the extension of these provisions of the Voting Rights Act. On Tuesday, June 25th, in a 5-4 decision, the Supreme Court declared Section 4B of the Voting Rights Act unconstitutional. Remember, Section 4B is the provision that determines which jurisdictions have to get pre-clearance. When it's unconstitutional, then no jurisdictions will have to get pre-clearance under Section 5. Chief Justice Roberts wrote for the court. He said, Section 4B is based on data from the 1960s and the 1970s. He said, times have changed. He said, race discrimination in voting is far less common than it used to be. He said, some of the jurisdictions that have good pre-clearance have higher registration rates in minority voters than jurisdictions that don't. He said, this imposes a real burden on state and local governments. I'll quote his exact word. He said, they have to beseech the Attorney General to approve their election systems. He said, this violates a principle of equal state sovereignty. The Congress must treat all states the same. Justice Ginsburg wrote for the 4 dissenters. It was a vigorous dissent. She urged deference to Congress in its judgment that these provisions of the Voting Rights Act remain necessary. What I find most puzzling about Chief Justice Roberts' majority opinion is I can't figure out what constitutional provision or principle the court felt was violated by Section 4B of the Voting Rights Act. I'm used to reading a judicial opinion, strike something down, and say, this violates free speech under the First Amendment, or this denies equal protection. But never does Chief Justice Roberts say what constitutional provision or principle is violated. Maybe implicitly the court is saying that Section 4B exceeds the scope of Congress's powers under Section 5 of the 14th Amendment and Section 2 of the 15th Amendment. But there's a test for that, articulated in City of Bernie versus Flores in 1997. The court never mentions that case or that test. The closest the court comes to a constitutional principle is when Chief Justice Roberts says that this violates the requirement that Congress treat all states the same. But where in the Constitution is that principle found? I'm not an originalist, but I think anything is clear about the Congress that passed the 13th, 14th, and 15th Amendments is they didn't mean that Congress had to treat all states the same. After all, that's the Congress that passed the Reconstruction Act. And if there is a principle that Congress must treat all states the same, then all of you as lawyers can get really rich for the rest of your career, bringing challenges to all of the federal laws that treat some states differently than others. Think of all the federal spending programs that treat some states differently. In theory, Congress can pass a new version of Section 4B with a different formula based on current data. It's politically unlikely that this Congress will do so. Because I'm skeptical that any Congress politically is likely to do so. How likely is it that members of Congress are going to be able to agree as to which of their jurisdictions are going to have to get pre-clearance for changing their election systems? And wouldn't any new formula that treats some states differently than others still violate the principle of equal state sovereignty? My fifth theme this afternoon is that the Supreme Court has taken a significant step forward with regard to marriage equality for gays and lesbians. And the case from Wednesday, June 26th, was United States versus Windsor. In 1963, Edith Windsor and the Aspire met. They began living together 4 years later in 1967. They lived in an apartment in Manhattan. They came to also own a house in Long Island. They lived together until Spire passed away in 2009. In 2007, they went to Canada and got married. In 2011, New York passed a law that allows and recognizes same-sex marriages. Under New York law, the marriage between Windsor and Spire was recognized, even though it occurred before the statute was enacted. When Spire passed away in 2009, she had a will that left all of her assets to her spouse, Edith Windsor. If federal law recognized their marriage, Spire's estate would owe no estate taxes. But Section 3 of the Federal Defense of Marriage Act said, for purposes of federal law, marriage had to be between a man and a woman. Because of this, Edith Windsor paid $363,000 in estate taxes. She then brought a challenge to this as denying equal protection and argued that Section 3 of the Defense of Marriage Act was unconstitutional. In a 5-4 decision, the Supreme Court declared Section 3 of the Defense of Marriage Act to violate equal protection. Justice Kennedy wrote to the court, joined by Justices Ginsburg, Ryerson, and Kagan. Justice Kennedy said that marriage is traditionally regulated at the state level. He said, and I'll quote his exact words, that New York gives dignity and respect to the marriage of Windsor and Spire. He said there has to be a very good reason for the federal government to refuse to do so. He said there wasn't such a good reason. He said the Defense of Marriage Act was adopted out of a desire to disadvantage gays and lesbians. He quoted the legislative history of the Defense of Marriage Act, which said its purpose was to express moral condemnation of homosexuality and to express support for traditional opposite-sex marriage. Justice Kennedy said, this animus is not a legitimate purpose sufficient to meet equal protection scrutiny. Chief Justice Roberts, Justice Scalia, and Justice Alito each wrote dissents, joined by Justice Thomas. As I said in my introduction, if nothing else, this is important, because now same-sex couples who are married, and there's soon to be 16 states that allow this, get benefits under 1,100 federal laws that previously only opposites married couples could take advantage of. The case certainly raises many unanswered questions. be decided if a couple is married? Is it determined by the law where they live, or the marriage is celebrated? Imagine a couple goes from Texas to California, where same-sex marriage is allowed. They get married here and they go back to Texas. Are they regarded as married because the celebration occurred here, or not because they live in Texas? What if that couple decides to file for divorce in Texas? Well, in fact, 2 weeks ago, the Texas Supreme Court heard oral argument in 2 cases is whether same-sex couples can get divorced in Texas, even though Texas doesn't recognize same-sex marriage.
Yeah, exactly.
Many of you are trial lawyers. Think of the following hypothetical. Imagine that this couple is involved in litigation in state court, or for purposes hypothetical, put it in federal court. They want to claim the spousal privilege. Spousal privilege is decided by state law. Do they get the spousal privilege or not? Don't mention this to my students because I'm thinking of putting it on their exam. What about Section 2 of the Defense of Marriage Act? It says that no state has to recognize the same-sex marriage from another state. If the Defense of Marriage Act serves no legitimate purpose, can Section 2 be constitutional? In July, a federal district court in Cincinnati issued a preliminary injunction against Section 2 of the Defense of Marriage Act, saying Ohio would have to recognize the same-sex marriage from another state, notwithstanding the provision of the Ohio Constitution saying that in that state marriage is between man and woman. And what about the state laws? 34 states that continue to declare that marriage has to be man and woman. Are those constitutional? Their challenge is now pending in courts across the country. The court might have resolved this issue in the other marriage case decided on June 26th, Hollingsworth versus Perry. As you know, in May of 2008, the California Supreme Court interpreted the California Constitution as creating a right of marriage equality for gays and lesbians. In November of 2008, California voters passed Prop 8 to amend the California Constitution to say that California marriage has to be between a man and a woman. 2 same-sex couples that wanted marriage licenses brought a challenge to Prop 8 in federal district court in San Francisco. Federal Judge Vaughn Walker held a trial, and then in the summer of 2010 declared Prop 8 unconstitutional as infringing the fundamental right to marry and denying equal protection to gays and lesbians. Judge Walker issued an injunction against the defendants, the governor, the attorney general, the registrar of records, and all under the direction and control to keep them from enforcing Prop 8 anywhere in California. The defendants then announced they weren't going to appeal Judge Walker's order and ruling. The supporters of Prop 8, a group called Protect Marriage, said it wanted to appeal to the Ninth Circuit. After briefing and oral argument, the Ninth Circuit certified to the California Supreme Court the question of whether or not supporters of an initiative could represent the interest of the state when government officials refused to do so. The California Supreme Court, you remember, unanimously said that the supporters of the initiative could represent the interest of the state. In February 2012, the Ninth Circuit then said the supporters of the initiative had standing to appeal, but they lost. Prop 8 violated equal protection. On June 26, the Supreme Court, in a 5-4 decision, vacated the Ninth Circuit's opinion. An unusual split among the justices. Chief Justice Roberts wrote the opinion for the court, joined by Justice Scalia, Justice Ginsburg, Justice Breyer, and Justice Kagan. Chief Justice Roberts said, in order to appeal in the federal court, a party must be injured. Chief Justice Roberts said, the supporters of an initiative are not injured if it's enjoined. Their only injury is an ideological one, and an ideological injury is not sufficient for standing. Now this means that there was no standing to appeal to the Ninth Circuit. As I said, the Ninth Circuit's opinion was vacated, but surely the 2 same-sex couples had standing to sue in federal district court in San Francisco. They were injured by the denial of marriage license, so the district court opinion stands. 2 days after the Supreme Court decision on Friday, June 28th, the Ninth Circuit lifted the stay of Judge Walker's order. Within hours, same-sex couples began to marry in California. Protect Marriage then filed an emergency writ in California Supreme Court, asking it to declare that Judge Walker's order applied only to the 2 same-sex couples in most of the 2 counties where they live. The county clerk of San Diego filed an emergency writ, asking the California Supreme Court to declare that he didn't have to issue marriage licenses to same-sex couples. The California Supreme Court denied the emergency relief and then dismissed these cases. So same-sex couples continue to marry in California. My 6th and final theme is that this is another amazing year before the Supreme Court. It's once more a term filled with blockbuster cases and more are likely to get added to the docket in the weeks ahead. There's a lot of important First Amendment cases this term before the court. Just to give you some examples, there's a very important case about separation of church and state. It's a case called Town of Greece versus Galloway. It was argued in the Supreme Court on November 6th. Town of Greece, 100,000 people. It's in upstate New York. Beginning in 1999, the town board began the practice of inviting a clergy member to come for its monthly meeting and lead a prayer. From 1999 to 2007, every month the town invited a Christian clergy member to come deliver a prayer. You know, 2/3 of those prayers were explicitly sectarian, expressly Christian in their content. 2007, 2 people complained of this. They said that it violates the Establishment Clause for the town to invite only Christian clergy to deliver Christian prayers. For 4 months, the town invited non-Christian clergy. And then for the next 18 months, reverted to inviting only Christian clergy. And 86% of the time, their prayers were explicitly Christian. Challenge with broad as this violates the Establishment Clause. The Second Circuit held that it was unconstitutional. The Second Circuit said that the town had become impermissibly aligned with the Christian faith. The Supreme Court is granted review. Many believe that there might be 5 votes on the current court. Roberts, Scalia, Kennedy, Thomas, and Alito take a much more permissive approach with regard to government involvement with religion and religious involvement in government. We'll see what happens here. There's some major speech cases before the court. On October 8th, the Supreme Court heard oral arguments in McCutcheon versus Federal Election Commission. In 1976, in Buckley versus Vallejo, the Supreme Court articulated the framework for campaign finance law under the First Amendment. The court said the government can limit contributions, the amount that a person gives to a candidate or community candidate, but the government can't limit independent expenditures. So if last year a person had $1 million to spend for Obama or for Romney, the government could limit the amount that the person could contribute directly to the candidate or a committee for a candidate. Contribution limits are allowed. But the government couldn't stop the person from spending the whole $1 million. Expenditure limits aren't allowed. Citizens United versus Federal Election Commission in 2010, who we've all heard of, said that expenditure limits on corporations violate the First Amendment. What makes McCutcheon versus Federal Election Commission so important is it involves contribution limits. The Bipartisan Campaign Finance Reform Act limits the aggregate amount that a person can contribute to candidates or give to the political parties. The question is, does this violate the First Amendment? Justices Scalia, Kennedy, and Thomas are on record as saying that they believe that all contribution limits, like all expenditure limits, violate the First Amendment. If Chief Justice Roberts and Justice Alito join them, that would mean that all contribution limits, local, state, and federal, are unconstitutional, would dramatically change the nature of elections in the United States. Now, the case that I'm most interested in, though I've got to admit it's not the most important case on the docket, is United States versus Appel, which I'll argue on Wednesday, December 4th. As you may know, Vandenberg Air Force Base is a closed military base. One must go through a gate where there's an armed guard to get in. There's a fenced perimeter. About 200 yards from that gate and that fenced perimeter, a green line is painted on the ground. The military says that's where the green line marks where the military base begins. Just the other side, on the public side of the green line, is Pacific Coast Highway, Highway 1. On the public side, on the edge of Pacific Coast Highway, there's a public protest area. It was designated protest area as a result of a settlement of a lawsuit a number of years ago. My client, Dennis Appel, has been regularly participating in protests in Vandenberg for the last 17 years. 10 years ago, he was part of a demonstration where blood got thrown against the wall, and he was issued a bar letter that prohibits him from entering Vandenberg Air Force Base. Well, Highway 1 here is technically on federal land. You wouldn't know it if you drove down it. There's no guards, there's no signs. And the protest area is on land owned by the federal government. When Dennis was observed participating in peaceful protest on Highway 1 in the public protest area, he was told by military authorities to leave. He refused to do so. He was prosecuted. He was convicted under 18 United States Code 1382. This happened a few more times. The district court rejected his First Amendment claim. The Ninth Circuit ruled in his favor. The federal government said to the Supreme Court, this is a matter of national security, and the Supreme Court denied this. On Tuesday of next week, the Supreme Court will have at its conference several cases that raise the question of whether or not the contraceptive mandate under Health and Human Service regulations violate the Religious Freedom Restoration Act. The Affordable Care Act said Health and Human Service had to promulgate regulations that would provide that insurance coverage supplied by employers would include preventative medical care. The HHS regulations say that employer insurance that provides preventative care must include contraceptives. There's an exemption for religious institutions, but otherwise employers have to do that. A number of companies across the country have brought a challenge to this. The case most likely to be heard by the Supreme Court involves a company called Hobby Lobby. It operates in 42 states and has 22,000 employees. But it says to force it to provide contraceptive coverage violates its religious freedom. Can a corporation have religious freedom? Does it significantly burden that religious freedom to require that its insurance for its employees provide contraceptives? Even if so, is there a compelling government interest in making sure that people have access to contraceptives? Because the court says it's a fundamental right to purchase and use contraceptives. I predict we will hear next Tuesday that the Supreme Court has taken one or more of these cases, and they too will confirm what I say. It's a really amazing time in the U.S. Supreme Court. So as promised, I saved 5 minutes for questions, and then we'll fill our hour required for the MCLE requirement. Any questions I can answer for our last 5 minutes? Please.
Sorry, I didn't hear what was the third theme. I was taking notes and I'm
Sure.
missing that.
This I can do. The third theme was this is the most pro-business Supreme Court that we've had since the mid-1930s. Please.
It goes back to the prior term, but the decision that upheld the Affordable Care Act, some have said the most consequential part of that decision wasn't actually the mandate issue, but the fact that the Medicaid spending could be something that they force states to do. Do you have any foresight as to whether that'll impact future federal spending cases?
I think both parts of the holding in National Federation and in business for civilians are important. I think upholding the individual mandate is important. In fact, 4 dissenting justices would have struck down the entire Affordable Care Act. I wonder now if President Obama wishes he had lost that case. And as you say, the other thing the court did was in a 7-2 decision find that the Medicaid portion of the law violated the 10th Amendment. This is the part of the law that says every state that receives federal Medicaid funding is a condition and to cover within their Medicaid programs those with 133% of the federal poverty level. The federal government paid 100% of these costs until 2019 and 90% thereafter. No lower court found this to be unconstitutional. What I found most surprising in this is the court said 7-2 declared this unconstitutional. The court said it was unduly coercive of the states. This is the first time in history that the Supreme Court ever found that conditions on federal spending were so coercive as to violate the Constitution. Countless federal laws put conditions on those who take the money. When is it unduly coercive? I think this is an open invitation for litigation because the court gave no criteria for deciding this. Thank you again so much.